Somebody just asked me, how do I issue a cure notice? Well, it really depends. What contract are you using? If you're using the right contract, aka the one inside the Sub 2 community, then it's very well defined for you and it's a fairly straightforward process. But ultimately, across the board, it comes down to you need to understand what constitutes a default. Your contract needs to define that. Failing to show up to the closing table, as in this case for the seller, constitutes a default on the part of the seller. That means the buyer has a right to issue a cure notice, right? You're in default. I need you to perform as you said you would. So your contract should have a section, maybe titled default and remedies or cure or anything along those lines. You have to define what a default is. Once the person is in default, then you have to issue a notice. That's usually a cure notice, notice to cure, whatever you want to call it. And then there's a cure period, which could be 1 day, 3 days, 5 days, 10 days. I've seen all of those in different contracts. When you issue a notice, it has to go to the person and place listed on the parties section. So party A, party B, party C, whoever's involved, you have to give them notice at that address. Does your contract allow you to send email as a notice, or are you required to mail something? If your contract did not capture somebody's email address and or your notices with a capital N does not include email, then you're going to be stuck using personal delivery overnight with signature or certified mail, something along those lines. And that kind of sucks. If you went ahead and got the email address, and if email address constitutes a valid means of communication for a notice, then you can simply send an email that with a subject line that says notice to cure default, give the address, and then the body would say something like, you did not show up to the closing for the property and are now, and maybe you've been unreachable, whatever's appropriate there. This constitutes a default on your part. Pursuant to section X, whatever that is, of the contract, you are hereby given notice to cure the default, and you have X number of days to comply. That's all that's necessary. You may have to write it out. You may be able to send an email. You may have to mail it. You may have to do personal service. I don't know. And if they gave you a PO box, good luck. Failure to comply, you can add something like failure to comply will result in legal action, can and will or can result in legal action, lawsuit, etc. And pursuant to section XYZ of the contract, any expenses, attorney's fees, etc., will be paid by the loser of the dispute. That's pretty much what a cure notice is. It's a notice to cure a default. You're in default, FYI, you have to cure it. And if you don't within this time period, I can pursue legal court action. Also, some contracts do a really good job of defining anticipatory breach of contract. I had a case where somebody sent me a text that says, we're not going to close. Well, now I have a screenshot of a text conversation where the seller told me they were not going to close. I don't have to wait for them to not show up to the closing table. I can immediately send them a lis pendens and file a lawsuit. They've already told me they're going to breach the contract. Okay, so that's prima facie evidence. Or if you have enough evidence to bring that anticipatory breach of contract to bear, then you can bring an attorney straight into it. Should you use an attorney for a cure notice? Maybe. It depends. What's the relationship been with the seller like? You're going to have to judge that for yourself. At Creative TC, we run this sort of stuff. We run these paperworks, sending notices, give people this advice all the time. This is all we do all day. We deal with these sorts of questions day in and day out for people's transactions.